was your reaper.
So this is a sentencing hearing in a very serious case when the defendant was still a teenager. Because of changes in how the court handles juvenile sentences, the judge now has to look at the case again. The defense points to his background and his conduct in prison, but the court also hears from a family member who has carried the impact of this for decades now. Watch how the judge works through that. My name is Dan. This is the Courtroom Files.
Day for sentencing in this case, and we are proceeding today partially in person and partially by video conference. I do have one person, Samantha Moore, I'm aware is I think going to make a big impact statement, who's attending by Zoom. I do have Ms. Moore in the Zoom session now. So can I have the attorneys place their appearances on the record?
Jennifer Bruggeman on behalf of the people.
Good morning, Your Honor. Allison Swain from the State Appellate Defender's Office on behalf of Marshall Sasby. Marshall Sasby is here in person today.
And sir, you are Marshall Scott Sasby.
Yes, Your Honor.
Mr. Sasby, have you had an opportunity to read and review the pre-sentence report and the updates to the pre-sentence report?
Yes, Your Honor.
Have you had an opportunity to discuss those reports with your attorney?
Yes, Your Honor.
Wish to explain or challenge the accuracy or relevancy of any of the information that is in these reports?
No, everything's good. Thank you.
I'm sorry to interrupt. I just want to make sure that Ms. Moore is let in. She wanted to be present for the entire sentence.
She is in session.
Okay,
She doesn't have her camera on, so
I see. Okay.
so you're not going to see her up there, but she her device is in the Zoom session and her audio is connected.
Okay, thank you.
The pre-sentence report did not disclose any prior convictions, any with a known constitutional defect. And sentencing guidelines in this case are calculated 225 to 375 months. Ms. Bergman, do you agree with that computation of the guidelines?
I agree with the totals, Your Honor, but as I indicated in my sentencing memorandum, I do believe that OB3 should be scored at 25 points. That doesn't affect the guideline minimum range, but I do believe that that would be appropriate, given that we can't score 100 points since this is a homicide offense, but under People v. Houston, which I cited in my sentencing memorandum, that at 25 points is appropriate in instances when a victim is killed. And we have 2 victims here, but I do believe that 25 points is appropriate, and I would like that to be scored. It's currently scored at 0.
Ms. Swain?
Your Honor, I believe, given that it doesn't change the range of the sentencing guidelines, we have no objection at this time for that.
All right, 25 points is appropriate under OV3 where there was life-threatening permanent incapacity that occurred to a victim. People cite People versus Houston, 473, Michigan, 399, 2005 case for the proposition of scoring 25 points for life-threatening permanent incapacitating injury was proper in a second-degree murder, even though the victim was killed. So it does appear appropriate to score 25 points. Will be 3. That does not change the minimum guideline range because we were already at the maximum minimum guideline range, and so it remained at 225 to 375. Any other issues with the guidelines, Ms.
No, Your Honor, thank you.
Does the defense have any guideline challenges?
No, Your Honor.
Before the court passes sentence, then Ms. Swain, is there anything you want to say on behalf of Mr. Sasby?
Yes, Your Honor. I first want to take a moment to acknowledge the tremendous loss that the Sasby family and so many others experienced by losing their loved ones, Carmen and Michael Sasby. Marshall's actions killing his parents were senseless. His siblings should have never had to endure that loss at such a young age, and his grandparents should not have had to have buried their children. We're here today because the Michigan Supreme Court held in People v. Stovall that a life with parole sentence for an offense committed by a child violates the Michigan Constitution's prohibition on cruel or unusual punishment. At the time of this offense, Marshall was 17 years old. He was a scared, immature, and impetuous kid. Today, Marshall is 35 years old. He has grown and matured from that abused 17-year-old into a remorseful and thoughtful man. He spent the last 17 years participating in programming, bettering himself and those around him. He spent that time self-reflecting and living with the pain of this offense. When fashioning a new sentence for Marshall, there are many considerations for this court. A sentence must be proportionate to the offense and the offender. People v. Boykin and People v. Eccles require this court to consider the mitigating characteristics of Marshall's youth at the time he committed this offense. Boykin tells us that youth necessarily impacts the analysis of the Snow factors, reformation of the offender, protection of society, and discipline of the wrongdoer. Finally, while this court is not required to make findings as to the Miller factors, the Miller factors inform the analysis of the mitigating characteristics of youth outlined by Boykin. I know I filed a lengthy sentencing memo, so I don't plan to re-argue everything here, but I want to talk a little bit about the relevant Snow factors and Miller factors as they apply to Marshall. I also want to be clear that none of the arguments I make are meant to be excuses for Marshall's horrible actions. Still, Miller requires us to consider what it defined as the mitigating qualities of youth, which include a youthful defendant's background, mental, and emotional development. The first Miller factor is chronological age and its hallmark features of youth. Marshall's chronological age is mitigating. He committed this offense when he was 17 years old. Our case law tells us that youth is always mitigating and must be considered for its mitigating impact. The brain science tells us that adolescents, compared to mature adults, have a reduced ability to control their impulses in a complex or emotionally charged situation. They also have a reduced ability to manage their emotions, and they place more value on the potential benefits of certain behavior rather than fully considering the risks. The inability to recognize certain behaviors or situations as risky or wrong can be exacerbated by early traumatic experiences. Marshall's age alone is mitigating and mitigates in favor of a sentence of 225 months on the homicides. The next Miller factor is the circumstances of the family and home environment. This case is unique because Marshall killed his own parents, who subjected him to extreme abuse and neglect. It may sound like I'm making excuses or justifying their murders, but that's not the purpose of talking about what it was like for Marshall while growing up. The law is clear that this factor is relevant to juveniles' characteristics of youth. Even if Marshall hadn't killed his own parents, what he experienced in his home as a child and growing up is significantly mitigating and would be relevant to this court when crafting a proportionate sentence. Miller tells us that a juvenile's circumstances of the family and home environment are relevant because children are more vulnerable to negative influences, including those from their family. They have limited control of their own environments and lack the ability to extricate themselves from horrific crime-producing settings. Marshall's father was abusive towards Carmen and his children. When Marshall was 3 years old, Michael, his father, knocked him down because Marshall got in the way of him threatening his wife with a machete. Growing up, not only was Marshall unable to extricate himself from his father's horrific abuse, but even his mother was frequently unable to leave and keep her family safe. The abuse was so extreme, Carmen tried to escape her husband's abuse on several occasions, fleeing to different states and even out of the country. Marshall grew up with an emergency backpack, something like his mother also had, in case they needed to escape for safety. Because of her own abuse, Carmen did her best to care for her children, but there were times when she left on her own, leaving Marshall and his siblings behind. On some of these occasions, Michael would have Marshall call his mom and beg her to come back. The escapes were never successful. They always ended up with Marshall's parents getting back together, and the violence would continue. Marshall grew up near his paternal grandparents and who would try to protect the children when they could, but Michael frequently would not let his parents see their grandchildren if they were trying to intervene between him and his wife. As he grew up, Marshall experienced abuse, like his father handcuffing him to his brother, holding him underwater in a pool, using a taser and electric collar on him as punishments. In the year leading up to this offense, Marshall's father, holding a 9mm gun, ordered Marshall outside and to face away from him. Michael shot Marshall in the back, causing him to fall to the ground. It wasn't until his father was standing over him that Marshall realized his father had switched out the Smith & Wesson for a paintball gun. Marshall grew up in tremendous fear of his father. He felt protective of his mother and wanted to help, but he was a child who also needed to be protected. And he was not getting that from the adults in his life. He spent a lot of time alone, retreating to the comfort of video games, fantasy worlds, and online friendships. He experienced things no child should have to experience, especially by the person who is supposed to be his protector. He saw things that no child is supposed to see. What Marshall experienced as a child, both trauma and neglect, mitigates in favor of a sentence of 225 months for the homicides. The next Miller factors are the circumstances of the event and the ability to navigate the criminal justice system. On September 23rd, 2008, Marshall got into a fight with his father about his cell phone and unjustifiably shot and killed his father and his mother. Marshall then threatened his sister Samantha's life when he pointed a gun at her and told her not to tell the police what really happened. He initially denied his actions, lying to police. Following the offense, Marshall was found to be incompetent for trial for a period of time. He was admitted to the Center for Forensic Psychiatry before he was eventually restored to competency. Marshall then pleaded guilty to second-degree murder and apologized, taking accountability for his actions. Today, he takes full responsibility for killing his parents and is credibly remorseful for the harm he caused his family and other loved ones. While the context of the strained and abusive relationship with his parents is relevant for this court's consideration, Marshall by no means argues that this excuses his behaviors. This court will hear directly from Marshall in his own words about how remorseful he is for the harm he has caused. The final factors are sort of addressed together. The Miller factor is the possibility of rehabilitation, and the Snow factors of reformation of the offender, protection of society, and disciplining the wrongdoer. All of which are mitigating as to a term of 25 months for the homicides. Adolescents grow and change. Case law tells us that rehabilitation involves the successful completion of vocational, educational, or counseling programs designed to enable a prisoner to lead a useful life free of crime when released. That's People v. Bennett. Case law also tells us that the Snow factors must be viewed through the mitigating lens of youth. As to the Snow factor of reformation of the offender, People v. Boykin tells us that, quote, an adolescent's greater possibility that his character deficiencies will be reformed necessarily transforms reformation of the offender, end quote. As to protection of society, Boykin tells us that a youth's heightened capacity for change compared to adults necessarily impacts the consideration of protection of society. When it comes to the Snow factor regarding discipline of the wrongdoer, Boykin tells us it's less supportable to conclude that even a heinous crime committed by a juvenile is evidence of irretrievably depraved character. Finally, as outlined in the sentencing memo, case law tells us that deterrence cannot be measured for the same reasons adolescents are less culpable, they are less likely to consider punishment. All three relevant Snow factors contemplate that adolescents change. Marshall's reformation, rehabilitation, heightened capacity for change, and how he has been adequately disciplined for this offense are all demonstrated through the work he's done when he's been incarcerated for the last 17 years. I want to highlight just a few of his accomplishments over those years and the work that he's put in the last half of his life and why he's deserving of a sentence of 225 months. First, I want to touch on Marshall's MDOC disciplinary record. In 17 years of incarceration, Marshall has incurred only one Class 1 misconduct and only 9 misconduct tickets total. He's been at the lowest security level possible for the last 12 years. His misconduct record is below the average for an incarcerated inmate in Michigan. His record is especially exemplary because we know that juveniles earn a lot of those early misconducts in the first years that they're incarcerated. And not only did Marshall not rack up a bunch of misconducts, he has been consistent over time. Next, I want to talk about Marshall's programming and education. In 2010, he earned his GED in prison. He's currently enrolled in Jackson College and is a member of the Honor Society. Marshall has meaningfully engaged in as much programming as has been available to him. Early on, Marshall sought out involvement in programming to better himself and change his way of thinking. He established himself as a leader and a mentor and became a facilitator for many programs after he took them. There are many letters of support from other incarcerated individuals attached to the pleadings before this court. The list of programming that Marshall has been involved in is extensive and also before this court in the pleadings. Notably, he's participated in programs like Cage Your Rage, Effective Communication, Personal Dynamics, Healthy Relationships, Critical Thinking, and much more. Marshall has instructed or facilitated programs like Critical Thinking, Conflict Resolution, and Inside Out programs with college students. Most recently, Marshall finished a personal integrity course and earned a 4.0 in his English course. In terms of trades and job readiness for when he comes home, Marshall has participated in study courses like Commercial Driver's License, Advanced Business, Real Estate, Small Business, and programs like Computer Science, Legal Research, Money Start Computer-Based Instruction, and Build Your Own Financial Future. Marshall has also been involved extensively in the Prison for Creative Arts program, also known as PCAP, through the University of Michigan, participating in creative writing and theater. As we think about Marshall's future, he recognizes how lucky he is to have had the support of his grandfather until his grandfather passed last year, and to have the support of his grandmother. Over the years of his incarceration, his grandparents were his biggest supporters. Today, Marshall has a network of people who are ready to support him. His grandma is here today. Many members of the Sato reentry team and Sato are here also to support him. When Marshall is released, he plans to live with his grandmother, or to Marshall, his Oma. Oma is eager to welcome Marshall back into society and has a bedroom set up for him in her home. Marshall also has the support from his brother Tristan, who he has been able to foster a relationship with over these years. He has the support from Sato's Project Reentry and PCAP professor Dr. Ashley Lucas through PCAP's reentry program linkage. In summary, as People v. Milbourne tells us, imposition of the maximum possible sentence in the face of compelling circumstances would run against the concept of proportionality. An analysis of the Snow factors and the Miller factors here demonstrate that a proportionate sentence is 225 months on the homicides. In the majority of cases where an adolescent committed first-degree murder, the sentencing range is 25 to 40 years on the minimum. Marshall took responsibility and pleaded guilty to second-degree murder when he was still a child. Sentencing Marshall to a sentence that is just as harsh or even harsher than the range for first-degree murder juvenile would be disproportionate. Marshall has used each year of his incarceration to better himself and those around him. Just as the law has indicated that he would change, just as the law has indicated he had a greater possibility for reform, he has demonstrated that. It is evidence in his programming, education, and work history. As to deterrence, the case law tells us it's nearly impossible to measure deterrence when it comes to adolescents because the same characteristics that render juveniles less culpable than adults makes them less likely to consider potential punishments. When it comes to protection of society, Marshall has been housed at the lowest level of security available to him for the last 12 years. In 2012, just a few years after arriving to prison, Marshall's risk assessment on a prison evaluation posed such a low risk for violence, MDOC removed him from the waiting list for mandatory violence prevention programming, as he did not need this because of his low risk score. The law tells us he has a heightened capacity for change, and he has changed. As to disciplining the wrongdoer, Marshall has been incarcerated since 2008. His actions are not those of an irretrievably depraved character, but instead a desperate, angry, and abused child. Marshall knows that when he killed his parents, he destroyed his family. In addition to his years incarcerated, Marshall is tormented each day knowing he is the one responsible for taking the lives of his parents. While there is nothing he can do to bring them back, and nothing he can do to heal the wounds he has already caused to his siblings, his grandparents, and the community, Marshall has already dedicated himself to giving back and has no plans to stop once he is home. Where he's availed himself to give to as much programming as possible, mental health treatment, and seen as a mentor, additional incarceration at this point is just that, punishment, and serves no further rehabilitative purpose. The guidelines that govern this case were scored aggressively and reflect the aggravated nature of this crime. Marshall has demonstrated the rehabilitative ideal. For these reasons and the reasons put forth in my sentencing memo and appendix, I'm asking this court to resentence Marshall to 225 months on the homicide offenses.
Thank you. Mr. Sasby, is there anything you'd like to say on your own behalf before the court passes sentence?
Yes, Your Honor. I was a horrible person who created a void and destruction within those I loved and cherished and in my community. When I took the lives of my mom, Carmen Sasby, my dad, Michael Sasby, my actions also caused feelings of betrayal. My actions also caused feelings of betrayal, pain, suffering, anger, and unthinkable fear. This especially was and is felt by Samantha, Devin, Tristan, and the rest of my family. Because of my actions, my siblings needed therapy and support from one another to just handle their daily lives. I don't know what my parents may have felt themselves seeing me, their oldest son, holding a gun, pointing it toward them. I imagine Dad felt confusion, rage, and sadness. My mom, her husband killed. I imagine she was overwhelmed with betrayal, grief, sadness, confusion, gut-wrenching pain. Never truly be able to correct what I've taken from the emotions of pain I place on my family, friends of the family, and society on that horrific day. Tristan almost told me about how you took your shoes off and said, "Mama, get at home." On that perfect day, you were so young, and what happened didn't dawn on you. You slowly learned that they were never coming back. I know you were picked on at school because of your parents were dead. Seeing your friends spend time with their families during holidays, when it reopens a wound, you'll never have those moments. You'll never experience having our parents. You never had a chance to have the conversation you could have had with them. And now you just had a son. And I know your son will never get a chance to know their grandparents. I'm so sorry for making you go through life with shattered pieces and never knowing how to put them back together. Devin, you were always the one with the golden heart who never wanted to hurt anyone's feelings. On that horrific day, you had no idea this would happen. I can only imagine your fear, terror, and confusion as you heard gunshots and saw Dad and Mom die on my hands. You saw how much I love Mom, yet I killed her. You might have thought you were going to die too. I traumatized you. I betrayed you. At times, I wondered if you moved out of state to get away from all of this. I know this is something you don't want to relive, and our parents weren't there to see your accomplishments. They weren't there to see you finish high school, get married, have children, become an amazing dad. In the Navy, become a state trooper, or start your own business. I took that opportunity from you. I caused a tornado that went through. It remains your whole life in a horrible way. I'm sorry. Samantha, I made you feel like you were going to die. I tore your soul apart. I was your reaper. It was like a horror movie for you. You saw me take Dad's life. I was your champion. And then you saw me take the life of Mom, someone I cherished. And you thought you were next because I threatened you. I know this fear that you've been living with your whole life, your whole world, has shifted again because of my resentencing. I don't want you to live in fear. I want you to find peace, security, and stability that I've taken from you because of my actions. I've put a wedge between you and our grandparents, bridges for everyone in our family. That took away the possibility of memories that could have been. I'm sorry. I'm sorry for being a horrible brother to you. I'm sorry for being a monster. I'm sorry I took the lives of our parents. to one family. I dropped the emotion battlefield on you. Parents should never have to bear their own children. You had plans for your own praise, but you had to buy bonds for mom and dad. You had to go through mom and dad's house and clean it. Wounds reopened again and again. You thought you were done raising kids, but now you're raising 3 more in your retirement years. But both of you were more worried about everyone else than yourselves. At the beginning, I wanted to push everyone away because I didn't deserve anyone. But you never gave up on me. You did what many people would never be able to do. You were always there for me. You never judged me. Thank you. Thank you for helping me, man. I am today. Grandma, I know you're no longer with us, and I want you to know you don't have to worry. If I'm given the chance, I'll be there, and I will take care of Oma. I'm sorry. I'm so sorry. My crime affected everyone. Just reading about it in the paper made people wonder, what if? I made the community start locking up their homes, and locking up emotionally. I cannot do what I did, so I wish I could. I realize that all the words I'm speaking today are not enough. I can't go back in time and pick up my family. What I can do is to strive every single day to be the person my family and community deserves. Today, I'm a man committed to continued growth of my journey of transformation for myself and those around me. I can now reflect and recognize how my daily actions impact others. And thank Jehovah for placing people in my life who have helped shape me into the man I am today. I'm grateful for the opportunity to take accountability for my actions and share these words today. To everyone I've harmed, I'm sorry.
And do the people wish to?
Yes, Your Honor, do you want to be heard by me or Samantha?
Whichever you prefer.
I would probably prefer that Samantha be able to speak first.
All right, Ms. Moore, if you are there, I'm going to send you a request to unmute your device.
I'm here.
Okay.
I'm
sorry. I'm sorry to interrupt, but I'm going to send you a request to start your video. If you prefer not to start your video, you don't have to accept that.
I would much rather not.
Okay. If you would just state your full name and then you can continue with whatever it is you would like to say.
My name is Samantha Moore, previously Samantha Sasby.
All right, you can go ahead.
Okay. I have prepared a statement. After hearing everything, I have made adjustments because I do feel that this court has never fully heard the truth. I will begin now. My name is Samantha Moore, previously Samantha Sasby. I am the sister of Marshall Sasby, who I will refer to as my older brother from here forward to avoid using his name, so I am able to get through this statement. Using my older brother's name in any sense creates significant distress for me, which may affect my ability to remain focused while providing this crucial, never before heard in this case statement. I have even covered him with a sticky note because I do not want to see him. For this reason, I will refer to him in general terms. I understand that this defense and criminal heavily rely on the victims to be too scared to relive these memories so that they may then paint their own images of what happened. So I am here at the risk of reopening these disturbing memories to relay the full truth. I am submitting this statement after many years of being unable to speak on these matters in a formal setting. Since the horrific tragedy, I have not felt able to testify or provide input in proceedings involving my brother. When I was a minor, I was not permitted to testify in court by my grandparents. And over the years, I have struggled with fear and distress when even receiving correspondences related to the case. I am here now to tell you plainly and without apology how my brother's crimes have destroyed my family's and my life. Since not being involved in this case as much as I could, I am not aware of what the court knows. Do they truly know this evil man's true story? I am curious if they are aware of the real reasons he snapped that night. His cell phone taken from him due to an outrageous bill, cutting his communications with a girlfriend in a different state where they planned to be wed in a Nazi-themed ceremony. I wonder if you were all aware of his dark side and his demons he believed he could summon to hurt others, or of the violence he inflicted upon his siblings throughout our childhood. I truly feel the courts are in the dark on how deep his evil is rooted. I am here today to fill in those missing pieces to this story. In 2008, he brutally stole the life of our parents in front of me and my younger brother, Devin. That moment, like so many others during our childhood, was only one episode in a long history of violence and cruelty. Growing up with him was not merely difficult, it was a constant nightmare. We endured repeated physical beatings, relentless psychological abuse, and sexual abuse when he felt it was deserved. As if those things weren't enough, he would turn our parents against us by destroying or damaging things. For example, dumping every single item of clothing in the middle of our rooms and telling our parents that we did it because we hated them. He often created situations designed to turn the adults against us while protecting his own image. What frightened me the most was how quickly he could change his behavior when authority figures or adults were nearby. Moments after hurting or threatening us, he would instantly smile, act calm, kind, and completely harmless. A perfect angel. I remember him hurting us. And then the moment he heard an adult approaching, switching demeanor entirely while silently squeezing or pinching our arms as hard as he could as a warning to not say anything. That constant message that speaking up would lead to retaliation shaped my childhood and is a large part of why I have remained silent and fearful for so many years. We, as children, tried to get help. We told our elders. Throughout my childhood, my older brother used intimidation and threats of violence towards my younger brother, Devin, to influence what he reported to our parents and family. Because of this, my younger brother would deny my accounts and support my older brother's versions of events out of fear. Over time, this led to my parents believing that I was not credible, as my statements were consistently contradicted by both of them. This pattern reinforced a perception within my family that my older brother was reliable and truthful, and that he could not be questioned. As a result, he learned the needed behaviors and actions to become a master manipulator. He easily was able to put on an act with a face to match an angel. Because of my family's failure to see through this, the harm continued and deepened, leading to that horrible night. I begged to be believed. No one protected us in time. The consequences of his actions are with me every single day. After all these years, I have cycled through numerous therapists and a long list of medications trying to heal from what he did, yet to truly find something to help me. I live with complex PTSD, crippling nightmares, panic attacks that strike without warning, dissociation that makes me feel like I am not in my own life, and a persistent derealization that steals my sense of safety and reality. These conditions have wrecked my health, affected my family and relationships, undermined my work and previous schooling, and forced me into a life shaped around fear and survival instead of growth and joy. Forever, our family will suffer because of this man. Family who will never get to feel their love. Our parents will and have already missed major life events. They have missed their grandsons' births, our weddings, graduations, ceremonies. Their baby boy, my youngest brother Tristan, will never know their voices or mannerisms. Life forever changed because of this man. I am angry. I am angry for what he did, angry at the long shadow he cast over my childhood, and angry at a system that has failed to stop him sooner. But beyond anger, I am terrified. The thought of him being released haunts me. I do not want him near me, my family, or anyone else he may encounter in the public. One of the most painful parts of this process has been hearing the narrative simplified in ways that erase what I experienced directly at his hands for years. Part of why I have remained silent for so long was because attempts to speak out about the abuse and fear within my family were minimized or explained away. My own grandmother stands on my brother's side, even after I told her the whole truth as a child. Likely, this is why she did not allow me to testify as a minor, as well as why she and I have not gotten along. Her defense is despicable and a dishonor to the truth, as well as a slight against my mother and her own son who loved her dearly. Even after disclosing what we experienced living with our older brother, the truth was dismissed rather than protected and brought to the court's attention. Her involvement with my older brother was one of many reasons why I left her home when I was only 16. Even after leaving their place of residence, her support was non-existent, pretending I did not exist, as she did with my mother countless times before, and even refused to support my continued education when I was in high school. The silence and disbelief of her actions follow me even now. I know the defense may focus heavily on my father's shortcomings and conflict within our household. So many stretched truths have been told over these years. It sickens me to hear these things about our father. While he was not perfect, he brought so many smiles to our family as well as anyone he encountered in the community. Many people have even come forward to tell us of the lasting positive impacts he left on their lives after his passing. To hear him being painted a terrible father or an abuser is sickening and a cheap excuse for my older brother's terrible actions. Yes, my family was not perfect, and there were unhealthy dynamics and discipline that affected all of us. I do not deny that. But I also need the court to understand that my brother's abusive behavior began long before the murders, and cannot simply be explained away as one emotional outburst. As far back as I can remember, I lived in fear of my older brother. The abuse, manipulation, intimidation, and harm I experienced from him were ongoing patterns of behavior that existed independently of any single argument or incident in the household. If anything, he was the favorite because he was never seen or caught doing wrong. Through the scapegoating and intimidation methods he practiced daily. I understand the courts may hear about his good behavior while incarcerated. I cannot say that behavior surprises me. In my experience growing up with him, he was able to present himself one way to authority figures and another way behind closed doors when he had us alone. One of the most terrifying aspects of living with him was that retaliation did not happen publicly. It happened privately when no one else was there to witness it, where he would whip us with belts. He would punch us. He used his little sister's body in any way he felt and screamed as loud as he could in our ears. He always made sure to get even. This is what created an environment of constant fear about speaking up or against him. Because of that, outward compliance alone does not make me feel safe, nor does it reassure me that the underlying danger is gone. I know his tricks. In many ways, his ability to appear controlled and cooperative to others was always part of what made him so difficult to protect ourselves from. He has shown a pattern of manipulation and control his entire life. His ability to charm and deceive is not rehabilitation. It is the same skill he used to harm us and evade accountability. If the court considers any reduction in his sentence or early release, I beg you to put the safety of victims and the community first. Do not be persuaded by polished behavior in custody. I am here to ask the court to recognize the full ongoing damage he has caused. This is not a past chapter that I can close. It is a wound that bleeds into every part of my life. I urge you to weigh that harm heavily in your decision. I am begging the courts to keep this man locked up, not only for my safety, but for my family and the public. I understand the courts may consider his good behavior while incarcerated as evidence of rehabilitation. I reiterate my urge for you to understand one of the most frightening aspects of his behavior was his ability to appear controlled, cooperative, and even kind to others while creating fear privately behind closed doors. The night our parents died, I truly believed I survived because I told him I would not speak against him and would lie to the police about his actions. This moment of fear for my life reflects the level of fear I lived under the extent to which I believed retaliation was possible if I went against him. Even now, as an adult with children of my own, The thought of his eventual release fills me with fear. That fear did not come from one isolated incident. It came from years of experiencing his terror firsthand. Please consider the absolute maximum sentencing possible for this man is an absolute nightmare when left unchecked. Do not allow his polished acts and words to fool you. He was less than 2 months away from being an adult when he killed my parents. He knew what he was doing. Please do not allow him to exploit this hole in the law. Thank you for hearing me today and for considering the real and lasting costs of his action. I am only alive today because I lied to him when he threatened my life that terrifying night. Please don't let this monster fool you with his good deeds and model citizen behavior. He is a true master manipulator who had our entire family fooled.
Thank you, Your Honor. As the court knows, I wrote a resentencing memorandum. I'm not gonna readdress things in there, but there are a couple of things that I wanna say for the record. One is, I believe it's worth noting that Mr. Sasby was originally sentenced on a second-degree murder convictions, one of a life sentence and one of 375 months to 750 months. It is because of the life sentence that we are here today. Again, as was indicated by Ms. Swain, we are here because of People v. Stovall, and this court's bound by that. But this court also has the ability to sentence Mr. Sasby to a lengthy term of years. There has been no parameters put on that term of years, except for obviously this court needs to and must consider youth as a mitigating factor when taking into account the snow factors and determining a proportionate sentence. That is not disputed. This court is in a very unique position, resentencing Mr. Sasby 17 years later. And again, I'm not going to reiterate the legal arguments and specific facts of this case. Mr. Sasby pled in this case, so in terms of a record, we are limited. I would urge the court to take Samantha Moore's statement and understand the complicated dynamics of this case and the selfish acts of Mr. Sasby and the significant detrimental impact it has had on this family, not only of Ms. Moore, but his siblings, his other siblings, Devin and Tristan, who have not provided impact statements, which is their prerogative. I would like to note that OB5 was scored at the maximum of 15 points. That is psychological injury sustained by a member of the victim's family. It absolutely does not adequately account for the psychological injury that Mr. Sasby has caused his siblings and his family. Just like this court can take into account Mr. Sasby's MDOC record, which I do not dispute that he has taken advantage of the programs available to him and has seemingly on paper benefited from them. But this court should equally be able to take into account what's happened to the victims over the last 17 years. They would not, back in 2009, 2010, when he was originally sentenced, been able to do that in the way that they are able to do that today. There are multiple versions that have been presented today and in the past of what happened, not only on that night, that day, but what has happened in this family prior to that. But there's no doubt, and defendant himself has admitted that he premeditated the murder of his father. While he did plead to second-degree murder, that premeditation is not in dispute. There's we're never going to know why exactly Mr. Sasby chose to murder his mother that night. He has apologized for it. He has expressed remorse. However, it also appears that it's quite likely that he killed his mom so that she didn't turn him in. He attempted to convince Miss Moore to lie for him so that he could get away with it as well. Again, this court is in a unique position. It must consider Mr. Sasby's potential for reformation, but it is also appropriate for this court to consider the impact on the victims, the protection of society, punishment, and deterrence, all while taking into account youth as a mitigating factor. The OV total in this case is 260 points, which is more than twice the maximum 100 points. The guidelines are at 225 to 375 months on the second-degree murder convictions. And we are requesting that this court impose no less than 360 months on the minimum. In addition, I would ask this court to impose a no contact with Ms. Moore. And again, as this court knows, it must resentence on all the offenses. We are asking the court to reinstate the same sentences on the other offenses, but we are requesting 360 months on the minimum.
Sentencing in a case where lives have been lost is as difficult as it gets. And I always say that, but this is a particularly difficult situation given the nature of the crime, the nature of the circumstances, and the nature of the emotional devastation that has resulted from what occurred here. The United States Supreme Court in Miller versus Alabama decided that mandatory life sentences without the possibility of parole for crimes committed before the age of 18 were unconstitutional. They violate the Eighth Amendment's prohibition on cruel and unusual punishment. In doing so, the United States Supreme Court acknowledged that as a result of adolescent brain development, children have diminished culpability compared to adults and a greater capacity for rehabilitation. The Michigan Supreme Court in the 2022 case of People versus Stovall held that life sentences with parole for juvenile offenders violates the Michigan Constitution's prohibition against cruel or unusual punishments. Consistent with Stovall, Michigan Supreme Court entered an order in this case vacating Mr. Sasby's sentence as it included a parolable life sentence. Cases decided by the United States Supreme Court and the Michigan Supreme Court make one thing abundantly clear, and that's that youth matters in sentencing juvenile offenders. Michigan Supreme Court has established 4 basic sentencing considerations. Those are reformation of the offender, protection of society, disciplining the offender, and deterrence of others from committing like offenses. It goes without saying that the offenses here are among the most serious that we face in society. 2 murders, felony firearm, assault with a dangerous weapon, and interfering with a police investigation. I received a lot of information about this case and have had the opportunity to hear the attorneys make their arguments, hear Mr. Sasby make his statement, and hear Ms. Moore make her impact statement. And those things are difficult at this point, having just heard it, to reconcile. Obviously, Mr. Sasby had no prior criminal history before committing these offenses. But he did commit these horrendous offenses that devastated the family. The parents are both gone. Mr. Sasby has been in prison. His siblings were left without the adults in their immediate family and were raised by their grandparents. Emotional wounds caused by these crimes obviously have not fully healed. They likely never will. And as we just heard, are, at least in one case, wounds that are still very raw. Mr. Sasby was 17 years old when he committed these offenses, which include the murder of his parents. His family and home environment as outlined in documentation that I have, were dysfunctional, and I would even say highly dysfunctional. Most significant characteristic of that environment in the record that's before the court is the physical and mental abuse that was occurring in the home. Started at a very young age, very early in life. And unfortunately, Mr. Sasby's mother was unable to protect him. And for years, he didn't have any viable means of escape due to his youth. Research suggests that juvenile offenders have a greater capacity for rehabilitation. And again, based on the record that is before the court, that appears to be on display with Mr. Sasby. While in the custody of the Michigan Department of Corrections, Mr. Sasby has taken steps to get an education, to address the issues that he faces as a result of his difficult childhood and the crimes that he's committed, and to help others take steps toward rehabilitation themselves. His record while in custody includes only one significant infraction over a long period of time. It's extremely low when measured against the typical rate at which inmates accrue infractions. Based on the report of Richard Stapleton that was attached to defendant's brief, stands in particular contrast to the fact that younger offenders are more likely to have a higher number of infractions while incarcerated. There's been an argument or a statement here today that that behavior is part of manipulation by Mr. Sasby to look good or minimize what's happened here. But I would note that the length of time that this behavior has gone on and the setting in which it has gone on suggests that it is something real and substantive as opposed to the manipulation. And so it is a very difficult job to try to reconcile, again, the crimes that have been committed and the devastation that results from those crimes on one side of the scale, and on the other side of the scale, Mr. Sasby's really exemplary record while he has been incarcerated. He has done everything that society asks a person to do in that situation. And it would appear at this point, based on all of that, that he is at a low risk to reoffend. It would appear that he has been significantly reformed during his time. And that given the decreased likelihood of his reoffending, that society would be protected by a lower sentence than what was originally imposed. With the understanding that sentencing for juvenile crimes, the focus shifts away from discipline and deterrence and toward rehabilitation and reformation. I don't believe that the discipline of the offender and the deterrence of the offender and others is completely removed. And I do believe it is still consideration. And it must be here based on the nature of the crimes. And so today is an attempt to balance two things that in some ways feel impossible to balance. Ultimately, I come back to what I said at the beginning is clear from the decisions of this US Supreme Court and the Michigan Supreme Court as it relates to juvenile sentencing, and that is that youth matters. And those factors must be considered and are considered here today. With respect to the interfering with the police investigation, sent to the court that Mr. Sasby served 57 to 120 months with the Michigan Department of Corrections. With respect to the assault with a dangerous weapon charge, it's the sense of the court that Mr. Sasby served 23 months to 48 months with the Michigan Department of Corrections. With respect to both of the second-degree murder charges, it is the sense of the court that Mr. Sasby served 260 months to 750 months with the Michigan Department of Corrections. And with respect to the felony firearm, it is the sense of the court that Mr. Sasby served 24 Department of Corrections. By law, felony firearm has to be served first, and the other charges are consecutive to the felony firearm charge. Ms. Holly, do you have the credit on? I don't have it can't find it quickly.
From 9/24 to 08, 9/24/08 to 5/14/26, it's 6,441 days. Any of that credit would go toward the felony firearm first.
6,000.
441 days.
So we'll have to do the math on that, but it's 6,441 days total. The first amount is applied toward the 24 months of the felony firearm, and the balance is applied toward the remaining charges, which are concurrent.
I don't know if crime victims' rights fee and state costs stay the same. Crime victims' rights fee since 2010 has gone up to 130. He was ordered 60. I don't know if that would change. State costs are the same.
I will impose the same costs that were assessed at the first sentencing. I believe that's appropriate given timing. Mr. Sasby, the bailiff is going to hand to you 3 copies of the notice of right to appellate review and request for appointment of attorney form. Need to sign the top copy of that form, and just in case that you received your copies of those forms, return that to the bailiff. If you want to request an appeal of your sentence and have an attorney appointed for you to do that, you need to fill out the remaining portion of that form and mail it to the address listed in the form within 42 days. Do you understand that?
Yes.
Did you want to add a no contact?
Thank you. We'll add a no contact provision that Mr. Sasby not have contact with Samantha Moore. The record should reflect that. Do have a copy of the signed appellate rights form from Mr. Sasby and placing that in the file. Is there anything else that needs to be addressed today?
No, Your Honor, thank you.
This way.
Nothing from defense.
All right, thank you for your time.
Alrighty, friends, it's rare that we go an hour and 20 minutes before I say once again, good morning, everybody. Welcome to TCF Live. Happy Thursday. But we jumped right into the deep end. And, you know, I think sometimes people think I plan this stuff. I don't. I catch stuff live. Sometimes I might have an inkling of what's going on, but normally I don't. And we just kind of see what we see here. And this was jumping right into the deep end of the pool right away. But I have info. Some of this has already been discussed in the chat. Some of it was discussed by the judge, but I want to make sure that we're all up to speed on what we just saw. So this was Marshall Scott Sasby, and he was born in 1990, and he was 17 years old at the time of the crime. The offense date was actually September 23rd, 2008. Michael Sasby, age 40, and Carmen Sasby, age 37, were his parents and also the victims. He shot both parents inside their home during a fight / argument about cell phone usage. He initially reported their deaths as a murder-suicide, so he tried to deflect. In November of 2009, he took a plea. The plea was 2 counts of second-degree murder plus related charges: felonious assault, felony firearm, and interfering with police. So on January 8, 2010, he was sentenced. That was Judge Timothy Picard, who is no longer on that court, as far as I know. He was sentenced to life in prison, but parolable. He was given 31 to 62 and a half years for the murder of his father. And the life in prison with possibility of parole was for the murder of his mother. 31 to 62 and a half for the murder of his father. Probably less because I think the father was viewed as an abuser there. 2 for the felony firearm. and he would have been eligible for parole at the 33-year mark. Now, along the way, and Judge alluded to this, the Supreme Court made two rulings. In 2012, they took up the case of Miller versus Alabama, and this is the U.S. Supreme Court, and it was decided there that defendants under the 18 at the time of the crime could not be sentenced to life without parole, even though he was technically sentenced to life with parole. But they found that unconstitutional in the Eighth Amendment. In 2016, the Supreme Court took up Montgomery versus Louisiana, which basically made Miller retroactive. And Michigan responded by implementing MCL 769.25, which basically opened the doorway for these youthful juvenile offenders to be resentenced, even if it wasn't life without parole, but a life sentence, because at the time, Michigan had one of the highest populations of juveniles who had been handed life sentences. So ever since then, which was around 2016, after the Montgomery versus Louisiana ruling where the Michigan legislature stepped in, ever since then, they've been kind of going through and cleaning up and resentencing these people. So that is the deal there. Now, with the sentence he just got, it translates to roughly 21.5 to 62.5 years. He's served around 17, so he's got a ways to go before he would even be considered for any kind of a release. So that's where things stand with that. So it's an incredibly difficult kind of hearing. The court has to consider youth, trauma, rehabilitation, the law as it stands now, but none of that erases what the surviving family went through and what they still carry. I'm curious what you think, though, about what went down, how the judge handled it, and if you would have done anything differently. So let me know down in the comments. And if you enjoyed this video, do me a favor and check out one of the two that are on your screen right now. Thank you so much for watching.